now that we have covered what a memo really is, and that you'll see that it's quite widely used in companies, whether you're in a marketing department, management department, engineering department, legal, every department, memos are somehow a part of a company. It's kind of ingrained into companies. Let's do a quick recap on the memo types or parts, and then we'll explain what a legal memo is and what a technical memo is. First, recall that in our previous video, the memo should be left aligned and adjusted, and the to, from, date, and subject can be double spaced, but the rest should be single spaced, and that you appropriately name everybody, and that you don't use short names or anything, like Maxie versus Rita Maxwell, president. You would want to address the person appropriately, because memos can be also part legal documentations companies may need to recreate or reprint for investigators or auditors. So always use the proper memo formatting. And that a memo has an opening statement, task segment, summary segment, a discussion segment, and a closing segment. And that your main goal in a memo is to address one big issue, not more, and you have a specific target audience that you can focus on, and that it's not long and it's to the point. No wasting people's time. This has got to be straight on what's happening. No extras. In a legal memo, compared to other typical company-wide memos, you're going to deal with something that's more analytical and could go beyond 1 to 2 pages. Sometimes it can be up to about 5 pages, but could have, in most cases, 1 to 2 pages. The objective of a legal memo, especially if you're in paralegal work or you're going to be working in a law firm or working in the legal department of a company, you need to be familiar with this, even if you're not in those, somehow what these look like. It's a product that provides legal analysis for the company. Say, for example, we need to know certain, I'll explain in a second, but you're going to be talking about the organization, the issue that you're trying to frame, and the legal analysis, all presented professionally. You're trying to be objective here. You're not persuading anybody one way or the other. It's just it's showing the situation, the legal framework that applies, and the outcomes possible. This for or against doesn't matter. You should be providing both. In the format, as a typical memo, you'll have the heading. But in this case, the questions that you're going to be presenting, that's the unique element here. Is this a jurisdiction question where you're saying which court will this apply? Because that could have a lot of questions, especially in the United States and even internationally. What claim could you be potentially making, if there is one, that we need to be solving or understanding? What are all the key facts? You have to, in a legal document, or as any case in business world and the legal world, you have to learn to discern the most important facts. This takes experience. And you should ask others, learn from others. In this case, in a legal format, I would ask myself first, if this fact wasn't there, would it affect my memo? If it was there, would it affect my memo? And how? And my results. And you want to be careful, like if it's that relevant that it has an impact on it, you might want to address it. If it has no impact on the outcome, then it may not be necessary. So not all facts are relevant facts. So learning that in the legal analytics takes time. In your discussion, you're going to explain the analysis of facts and the law, how the law ties to it. And in the conclusion, you would have a summary analysis. What are possible outcomes? Should it be jurisdiction A, B, or C, for example? So that's the basics of a legal memo, and when you're trying to address specific questions. In business world, you're going to come across legal memos that are kind of like contracts. They're a little bit different. One is called a memorandum of understanding. A memorandum of understanding is an agreement between parties, bilateral or multilateral. They're not necessarily a contract. It's an agreement to communicate or create a contract or come to a contract. So So it's not legally binding. Let me correct the adjustment here. It's not legally binding, but shows a willingness of parties to take an action towards a contract or for a contract to move forward. That part can be binding in a sense in a court. Like, what was the intention, implied or explicit? So it's important that memorandums of understandings between multiple parties, particularly externally outside the company, that even though it's not legally binding for the agreement you're achieving, that you guys are having an intention to come together and communicate. And this is great for initial discussions for a big contract, such as a sales contract, or the purchase or sale of a company or subsidiary. It is important that you have the memorandum of understanding to begin the conversation. Inside that will come a non-disclosure agreement. Should they agree to the MOU, a non-disclosure agreement should follow to ensure that information has boundaries. What can be shared, what can't be shared, and what courts does this apply should there be a sharing of information issue. So be careful. Memorandums of understanding are a pretty big deal, especially in mergers and acquisitions. The advantages of an MOU is that you establish mutual intention, share an understanding for each other's goals and objectives. They're aligned. Finalizations of MOUs have a paper trail of records to show that there's been negotiations, that there was communications, that there is no ambiguity here. So should there be a question of implied intents? It provides an ease of exit should that there not be an agreement at the end. We finally said that maybe this deal is not good for us. We can walk away. MOU comes to an end. And because the MOUs are outline objectives, it helps serves as the agenda for what we're trying to achieve in our negotiations. It's the starting point. The disadvantage being that they're not legally binding and that anybody can walk away at any time. Now, that's where, without consequences, and that can make business a little bit of doing business a little annoying, but the MOU is a great starting point that creates stability in the communication and up to or 3 or more parties coming together. So there's a lot of advantages. The fact that it's not legally binding is just one part. Other legal memos that you will hear about will be called Memorandum of Association. This is binding. This is how you start a company. They're the articles of a company. So when you hear Memorandum of Association, this is the beginning of a company or an organization, profit, non-profit, what have you. So memorandums of association will be setting out the rules and the bylaws, voting structure, stocks, should it be a stock held, etc. The memorandum of understanding is the preceding element of a contract. It does carry some weight in court, even though if it's not legal, particularly in situations of mergers and acquisitions, real estate contracts, and international treaties. You will also hear it called a letter of intent. An offering memorandum, used to attract outside investors, is a great way to put out there, like, we're offering you to do this. So it could be a request for proposals. We're making an offer to bring out people to come and invest in our company or to buy into this contract. A confidential information memorandum, which is not an NDA, as I mentioned before, a non-disclosure agreement, is used in mergers. Once again, let me readjust. It's used in mergers to convey important information about a business for sale, its operations, financial statements, management team, and other data to help the buyer understand the value of the company, any legal issues with the company, what is the real company itself, like the most important elements, and that they can have as a starting point for their research or their due diligence in their buy. Confidentiality agreements are also binding agreements and commonly used between parties sharing proprietary information. That would be your non-disclosure agreement. Confidentiality agreements are slightly different because a non-disclosure is about how information is shared. Confidentiality is that should something happen or discussions happening in our group, we don't want that to get out. So you're not going to share that as well. So that's kind of next level of it. So legal memos are quite complicated. Took most of this video. I hope you understand that there's a first purpose of a legal memo. It could be an analytical question that we're trying to answer, or for basics of business like a memorandum of understanding or an MOA. are very essential for businesses. So if you're going to be starting businesses, selling businesses, going into complex contracts, you need to know this, regardless if you're a lawyer or not. And you'll be surprised. Many people use NDAs and don't even know what's behind them. The technical memo. A technical memo is different than your legal memo. It's very specific here. You need one piece of information you're trying to find out here. It could be a technical component. Maybe why the door latch opens on a car in this way and ensuring that this defect product doesn't happen again. What's required of it. So very, very specific engineering questions will be asked. And only technical, capable people will be reading this. So somebody from marketing or somebody from finance will not be reading an engineering memo as much as an engineer will not be reading a finance calculated memo. So very specific audience. They're very knowledgeable of the item that you're selling or talking about. So its uses are documenting a design, analyzing a technical problem, reporting on research or experimental results. Pharmaceutical companies use technical memos. Documenting technical matters that seek clarification of information. Once again, move that over. There. The format needs are slightly different. Let me put that in the corner. You have the introduction, the main body, and the conclusions and or recommendations. You're not giving a call to action. You may be giving one, but it's not usually the case. The main body will be more complex. It'll be almost as if you're writing a thesis paper. And it will be very detailed, full of images, graphs, and tables. A memo of this type does not have to be 1 or 2 pages. It can usually be up to 30, 40 pages, depending on what's necessary in the memo. I still recommend, in cases where images can be put to the end, should be put into an appendix or attachment section. Or you have a front cover that gives you that basic abstract or executive summary of what this memo is going to be addressing before going into the final, meat and potatoes of the memorandum. That's what I would recommend. In a style rules, once again, keep it to one topic. That's challenging, particularly in this area. Figures and tables and equations should be numbered and easy to address and find in an appendix or reference section in the body of the text. Keep sentences short and direct. Once again, this is not a novel. This is not legal language. We're looking at very technical words. And keep paragraphs structured to the document in consistent, clear formats. Headings, subheadings, and underheadings of that will make this easy to read for your audience. And, wow. Every paragraph should have a topic sentence to help address the primary idea of that paragraph. So making sure you bring up what's going on. Remember my first video, the tools of the argument in the paragraph, the claim, warrant, data, things like that will quantify and create value in your paragraph. But that first sentence is what I'm talking about here. If the document's very long, cover pages, like I mentioned, abstracts are very helpful. So we've covered the different elements of a technical memo and a legal memo. I really hope this helps. Every one of you is going to be going in different fields, but for sure you'll be coming across these in different ways. So be aware, especially if you go into management, the legal memos will be definitely coming across your desk.